so I'll make it quick. I think I know the vast majority of you, but I am Professor Matt Chick, and I listed kind of my titles here for a specific reason, but I'm an assistant professor in the Political Science, Law, and International Relations Department. I am the pre-law advisor, I am the legal studies coordinator, and I am the advisor for the Law Club. I am also one of the co-directors of the Institute of Public Service. My two co-directors are over there getting something to drink, Professor Laurel Elder and Zach McKinney, and I kind of am supposed to captain the kind of law and policy related sort of events here. And I mention that, like I said, not just to kind of list all my titles for you, but rather because I think it's kind of symbolic of the layers and levels of coordination and organization that putting this event took. It really is symbolic too, in the kind of the truest sense of that word, but also not my symbol. The main symbol, the person who did the vast majority of that coordinating and organizing was our amazing alum here, Tom Holmgren, who I'm going to turn it over to in just a second. But I thought maybe even before that we could just give him a quick little round of applause. Tom, thank you so much. But really, just so you all have some sense from start to finish, this was Tom's idea, this was Tom's material, this was Tom's scheduling, this was Tom's judging, quite literally, this was Tom's finding other judges, and this was Tom's generosity. So it has been tremendously impactful for all of our students in a myriad of ways, many of which I was trying to relay earlier to Tom, and I'm sure you'll all take a minute to express any of the ways that it was impactful for you. And so while we're grateful to everyone who helped put this event on, like I already mentioned, my co-directors, all of you students, many of you sitting out here I know actually participated in this event, lovely folks at Aramark who got the room set up for us, and put out the great spread that's behind you. By the way, please help yourselves throughout. And the tech services people who made sure the mics worked, and we have a live stream going. This will all be available for you on YouTube later on. So I had another little bit where I was going to explain a little bit about the competition, but when Tom got here, he said, like everything else, he's going to handle that part. So I'm going to turn it over to him right now, and thanks so much for being here. Thanks so much for being here. And with that, Tom Holmgren.
So just before we get started, just introductories. I'm Thomas Holmgren. I graduated from Hartwick in 2013, and then I attended the University of Connecticut Law School. I'm an attorney in New York City. Mostly now I do construction defect and labor law cases. Done a lot of environmental cases before. And then, you know, coming up through the ranks when I was in Albany, I did everything. And then some general liability stuff, but I've done a lot of different stuff. And when I was in law school, I was very active in moot court and would travel around the country, do this sort of stuff. So this was a fun problem. And then we have two great judges to my left. So we're going to first start with Carlo. He can introduce himself.
I'm going to stand up because I don't have Tom's height, and I want to make sure that everybody in the back sees me. Well, first I just want to say I can't believe you put this together. This is amazing. I saw this problem, and by the way, you guys who argue this problem is quite impressive because those are very serious problems, legal problems that to this date, most attorneys don't know the answers to. So I'm an attorney. I practice in civil rights and employment. I represent a lot of individuals with disabilities, and I've argued before Second Circuit several times, appellate division several times, had many trials, but one thing that I have never done is this. What you guys are doing, I never had an opportunity to do, and you guys should be very proud of yourselves because this is really an amazing opportunity, and you will realize later how much you learn from this. There are attorneys who go their whole lives without arguing before a panel of judges. So you are doing it right now, although we can call ourselves judges. Right?
Yes, tonight.
Okay. So I just want to let you all know that to this day, when I'm arguing, I get nervous. If I'm doing a trial, I get nervous. I know you're nervous. That's okay. All right? So just relax. I know you're overly prepared because that's what Hartwick students do. So don't get nervous. Do your best, and everybody's gonna have a lot of fun
you wouldn't know, this case, in a few minutes here, it turns into the Supreme Court. There was a case at a district court level, which you'll hear the competitors reference, where there's finding of facts. It's basically a trial court. It's a trial court. Whoever wins there, unfortunately, that decision got appealed. So that went to a fake circuit, the 14th Circuit. We don't have one of those yet in our country. But just like it would any circuit court, if that case gets appealed, it goes to the Supreme Court. They grant it. So the Supreme Court here is hearing two issues tonight. One with respect to a school's haircut policy, which for the baseball team would not allow a participant to play if their hair is longer than shoulder length. And the second argument you're going to hear about is the defining liability for baseball stadium owners with respects to instrumentalities of the game, those being bats and balls that could go into the stands. The school corporation you're going to hear from is going to argue that there should be something called the baseball rule, which says that if there's a stadium that has enough protection in the most dangerous area, that being behind home plate, that as long as there's enough seating there, they're basically absolved of liability from a foul ball hitting someone. And then, of course, the other side will argue that that should not be the rule. The fact pattern here is that Kevin Wagner is at first a sophomore when the case starts, wants to play on that baseball team, but he's got a hippie hairdo, and he's not allowed to play. That's all you really need to know about Kevin. What you need to know about his mom is his mom eventually is watching a game while going to a baseball game at the school, and she's hit with a foul ball on her way back from using the restroom, away from where her seat was. That's all the facts you need to know. That's the issues you need to know. And from here forward, for the next hour, it will seem like we are in the Supreme Court. Thank you. The court will now call docket number 240123, O'Yarn Hill School Corporation versus Nick and Karen Wagner on behalf of their minor child, Kevin Wagner. Petitioner, you may proceed when ready.
Good evening, Sir Chief Justice and Honors. My name is Madeline Rodiger, and here is my co-counsel, James. Today, we are representing the Orion Hill School Corporation. Today, Your Honors, you will hear from the opposing counsel some baseless allegations that are simply not true. There is no evidence to support that Orion Hill School District, St. John's High School, or Coach Bullock has infringed upon Kevin's 14th Amendment or due process rights. Your Honors, we would like to prove that 1, the school district did not violate Kevin's 14th Amendment rights, 2, prove that there's good and reasonable justification for the haircut policy, and 3, show that the haircut policy is specific to baseball and baseball only and is not gender discriminatory. Your Honors, the opposing counsel will try to claim gender discrimination. They will try to argue that playing a sport is a right and not a privilege. Your Honors, we ask that you listen to our evidence with care and help set a precedent that a school having its students' best interest in mind is not arbitrary or unjust. We are here to prove to you today that having a haircut policy is not a violation of Kevin's due process and 14th Amendment rights.
Can I ask you a question about your due process claim?
Yes.
Okay, so what is the interest, what is the right that you claim is being violated?
Because they're claiming that there wasn't enough time for Kevin before he was terminated from the baseball team. And so his due process was violated because there wasn't a correct amount of time to do so. But in reality, Kevin was allowed to play on the baseball team between the dates of March 15th through March 20th of 2016. On the 19th of March, Coach Bullock told him, you must cut your hair by the 19th, or by the 21st, and if it's not done by then, you will be terminated.
Well, counsel, doesn't that cut against you? Because if Kevin was able to play.
He wasn't allowed to play. He was allowed to be on the team, but he could not play in any games. He could not play any practices, but he is still considered to be on the team.
And what's the haircut policy at issue here?
Can you repeat that question?
What is the haircut policy that Kevin was supposedly violating?
Because his hair is too long. Coach Bullock wants a clean-cut image for his team, and that creates team unity. It creates a brotherhood. It creates a bond between team players, and a clean-cut image allows these boys to play together. I mean, an image is the most important thing. It's how you present yourself as a school, and a school is going to want to do that within their best interest. So,
Counselor, I think everyone here is in agreement that understands why the coach wanted the guys to wear their hair short.
yes.
I think we understand that. But I believe that what they're arguing is that the right to wear your hair is a fundamental right, however you want. And so if it is in fact a fundamental right, then you need to present a compelling reason to legislate it. Whereas if it's not a fundamental right, the length of wearing your hair however you want, if that's not a fundamental right, then all you need is a rational basis for imposing that restriction. I think that we can all see this as rational, but is it compelling? So I think the first question that you need to address is the right to wear your hair a certain style a fundamental right?
So, Your Honor, actually, the 14th Amendment, that no state shall deprive any person of life, liberty, or property without due process of law. To make a procedural due process claim, it requires a plaintiff to show that, one, a violation of liberty or property interest in our case. Kevin has no constitutionally protected property interest in participating in an extracurricular sport. Kevin chose to play baseball on his own free will. There is nothing that says in our Constitution that Kevin or any other boy must play baseball.
But that's the right that's being infringed upon is his expression of self, right? The way he wears his hair. And aren't there cases that have portrayed that we've held before, that ability to, express yourself is a fundamental right?
I mean, that is correct, but there are two cases that I would like to cite. Give me 1 second, please. So the case of Davenport versus Randolph, that court upheld the ruling requiring interscholastic athletes to be clean-shaven, and Humphreys versus Lincoln upholding the removal of interscholastic athletes for violation of rule prohibiting facial hair during the football season. So this is a precedent that has been set long before this case has even come forth to the Supreme Court today.
So, but the question I asked earlier is, what is the interest that they allege was violated? So you just described for us what the 14th Amendment protects, right? The right to life, liberty,
And property.
and property. Okay, so which of those rights, life, property, or liberty, do they allege is being violated by
They're
this?
arguing that Kevin's liberty is being violated, but there is many different versions of liberty. Your hair is not your only form of self-expression.
Okay, so they're not arguing property. They are not arguing that Kevin has a property right to participate in sports with whatever hair he has. They're arguing a violation of his liberty interest?
Yes, Your Honor.
Okay, so assuming that we find that there is a violation of, that there is no violation of protected right, okay? What about the due process argument? They argue that they were not offered an opportunity to challenge a decision made by the corporation. So what about that? Was due process provided?
Yes, I mean, Coach Bullock provided Kevin an adequate amount of time. Kevin's mom also met with the superintendent, and the superintendent said that he will not let Kevin off because Kevin has no reason to not want to cut his hair. There is no medical reason, there is no religious reason. He simply does not want to. And Kevin has that liberty to choose to play baseball. If he doesn't want to follow this haircut policy, Your Honor, he doesn't have to. He can go play a different sport. Football, track, wrestling, none of those have haircut policies.
What about the equal protection claim? How do you address that? How do you explain the difference between the softball team not having such a rigid policy and the baseball team having that policy?
The haircut policy is applied to male athletes only specifically playing baseball. In the 2013 policy, it says that all athletes are subjected to however their coach wants their hair to be. It is not specifically saying all men or all women. It is saying all athletes. Some coaches didn't want to imply a haircut policy, and that's what they were allowed to do. Policy 13 allows them to do that.
But isn't it arbitrary to allow the coach to make that decision alone?
No, because Kevin, he's giving up some of his rights and liberties when he's playing because it's not constitutionally protected to play a sport. And so like I said, Kevin is choosing to do this, and for him to claim that it is arbitrary or unjust when there is justification for having a haircut policy.
What was the justification provided by the school here?
It creates team unity, Your Honor. Team unity is the most important thing. It presents an image, and the school wants that image to be presented out. It's in policy 2013 saying, let me find that, Your Honor.
Counsel, what if it was a different sport? So it's kids on the basketball team, they're actually supposed to have long hair. They need to have hair below their shoulders because the coach likes rock and roll and thinks it looks cool. Is that a good enough justification?
So, Your Honor, policy 2013 doesn't allow athletes to have long hair at all. So, therefore, that's not relevant in this case. Policy 2013 says that hairstyles which create problems of health and sanitation, obstruct vision, or call undue attention to the athlete are unacceptable. Athletes may not wear haircuts that include numbers, initials, or extremes in differing lengths. Mohawks are not acceptable, and hair coloring is not permitted. Each varsity head coach will be responsible for determining the acceptable length of hair for a particular sport.
But that still leaves the question of how long is too long up to the judge, or sorry, up to the coach, right? So that does still seem very arbitrary.
I mean, no, because if Kevin knows, let's say, for example, that wrestling, you're allowed to have your hair a little bit longer than you are in baseball. He can have the free will to go play wrestling. He can go do wrestling. There's nothing stopping him from doing that.
So there's that Veronia case,
Yes.
right? And Veronia will allow the urine testing for student athletes, but not corporal students, not students that would generally maintain.
Yes.
Isn't this a bigger intrusion than urine testing because of the fact that it's not a one-time occurrence and Kevin's hair doesn't get any longer when he goes home? The prohibition on the diamond affects his life off the diamond.
I mean, hair is not your only form of identity, Your Honor, and Kevin could choose to express himself in any way he wants to on the baseball field. He has the freedom to choose what type of cleats he wants to wear, what clothes he wants to wear to practice. But to answer your question, yes, it is we agree that having a urine sample is way more arbitrary than having your hair cut. That comes out of your body essentially, and like for a school to say, let me see your urine, isn't that meant for like doctors? And it makes sense though, because
going back to the standard, right? So isn't there a way to do this where it's less of an intrusion upon Kevin? Why couldn't Kevin put his hair in a bun as if he was typically a female, or some other way to just have it so it doesn't hang below his shoulders?
Because Coach Bullock wanted the boys' hair to be above the ears, the collar, and the eyebrows. That still leaves Kevin with a significant amount of hair. It's not like he's buzzing it short. He still has hair to work with.
But should we be ruling on this case based on what Coach Bullock thinks is appropriate?
I mean, Coach Bullock is simply doing what the superintendent of his school district is asking him to do. That is his job to do that. It's what he's hired and paid to do.
Going back to the urine case, did the urine policy apply to all students?
It only applied to student athletes and cheerleaders. And
Males and females?
yes,
Okay. So that is a little different than what we have here, right?
yes.
And the haircut policies that have been upheld by different courts around the country, you referenced the shaving case for the football members, but I believe that was the Louisiana, the highest Louisiana appeals court. But has a haircut policy in general been upheld?
I could not find any evidence to support that, but that means we can set a precedent. That means we can create a precedent and make a change in the court system. We think that that's an important thing to do, because having precedents is not always a great thing. It's not great to follow the same rules that we've been following, and it's important to set new roads. And thank you, Your Honor. I would like to mention that there is a precedent set by HSSA versus Kohlberg that a student has no constitutional right to participate in interscholastic athletics. Playing for a sports team is a privilege and not a right. Sorry, Your Honor. Okay.
So in the hair of those have been with respect to police officers, military, schools. So those are completely distinguishable from this case, or should we find similarities to
We should find similarities to this because it shows Kevin how to be professional. Clean cut is professional. It teaches Kevin that he just can't do whatever he wants because he doesn't agree with it, because he has a job to do. When he is choosing to play baseball, he's choosing to follow that rule.
Is it possible the next year, if Coach Bullock is no longer the coach, that the next coach may find that longer hair is professional?
Yeah, that's completely up to the coach as listed in policy 2013. And if Kevin wants to wait that long, then he is welcome to do so.
So how do we reconcile that? If we decide in your favor now and find that the policy is appropriate and constitutional, what happens next year?
Policy 2013 still stands, and it proves that policy 2013 is not arbitrary or unjust.
What if that new coach takes it further? Instead of saying, I want hair cut above the ears, instead he says everyone has to be bald. Is that still justifiable?
It's justifiable because, like I said, policy 2013 gives that right to the coach. That is undistinguishable, that is unwavering, that is in this specific school district, that is unwavering, that does not change. I would like to move on to my conclusion, Your Honors. Sir Chief Justice and Honors, as we look back at all the evidence presented, there is no doubt that Orion Hill School did not violate Kevin's due process and 14th Amendment rights. We looked at the requirements of policy 2013 and how they do not violate 14th Amendment rights and why Kevin was not violated. We looked at the baseless claim that Kevin was being sex discriminated against, and we looked at the benefits of having an athletic code of conduct and why it benefits student athletes. I ask that you look with all of the evidence with care and to rule correctly with the school. Thank you for your time and consideration.
Thank you. Co-counsel?
Sir Chief Justice and Your Honors, may it please the court. My name is James Dima, and I am here with my co-counsel Madeline, representing our client O'Yarn Hill School Corporation. Today we address the regrettable injury of Mrs. Wagner, a spectator struck by a baseball near a concession stand. While unfortunate, this incident highlights the limits of liability in activities with inherent risks. Our opponents may argue that the stadiums must evolve beyond the baseball rule to ensure safety in non-seated areas, or that the presence of prior incidents made this injury foreseeable. However, such arguments overlook critical factors. The baseball rule provides a practical framework balancing safety with the nature of the game, requiring stadiums to offer reasonable protections, not absolute ones. Additionally, a stadium cannot reasonably foresee or eliminate every possible risk without fundamentally altering the experience of attending a game. Your Honors, our argument rests on 3 key points. First, there is an assumption of risk. Second, there is proximate cause and foreseeability. And third, there is a lack of gross negligence.
Can you tell me what the baseball rule is?
The baseball rule is a limited duty rule which protects the stadium from having to be liable from foul balls if they go beyond home plate.
Well, it defines a duty, right? So what is, under the baseball rule, what is the stadium owner required to do?
They're required to put netting behind home plate, which is the most dangerous area. It is also what O'Yarn School District has.
And how are we able to tell if there's enough netting behind home plate?
We're able to tell by the lack of injuries that happen behind home plate.
So I think in a couple of courts it said that we're essentially, if there's a seat, if there's enough seating, adequate seating behind home plate, then baseball stadium owners are not liable from instrumentalities, bats or balls flying into the stadium or the stands,
Yes.
right? I'm asking the question of, when we write this decision, how are we supposed to say that we know that there was enough adequate seating behind home plate?
Well, Mrs. Wagner had the opportunity to acquire that seating, and she chose not to.
Where did Mrs. Wagner sit in this? Okay, what did the district court say about that?
She sat in the 13th row of, I believe, the upper stadium.
In addition to the netting, what if any other precautions that were provided in the stadium?
Other precautions were warning signs and an announcement before the game to watch out for fly balls. She also was not in her seat when she was struck with the baseball. She was near a concession stand.
Is it true that the location where she was struck with the ball was a location where she couldn't actually see the batter?
Yes, that's correct.
Okay. Does that make a difference? Should that make a difference for us?
She should have been aware of keeping a self-awareness. She has been to plenty of baseball games her whole life. She's an adamant fan of baseball. And it's a high school game. There's not many distractions going on.
But what if she did? You said that she did not buy the seat behind home plate. But what if she did, and then she was struck in the same place? Would that change our analysis under the baseball rule?
No, I don't believe so. We don't believe so. First, I would like to talk about the implied assumption of risk, though, that Mrs. Wagner took. She chose to attend an activity which she loves, and she's been a fan of her whole life. The tickets stated there that she assumed all risks, and even if she didn't read the fine print, going to so many games gives a basic understanding. There's balls and there's bats. There's a possibility anyone could be hurt, especially if you're not behind the netted seating.
Is baseball itself an inherently dangerous activity? Because most of the time we think of assumption of risk, we think of it in the context of skiing, downhill skiing, where you may get hurt, or someone who chooses to participate in a local rodeo and wrestle with a bull.
Fastballs can travel upwards of 100 miles per hour. I would assume that it's a very dangerous sport, inherently. I would like to also talk about foreseeability, though. And with foreseeability, there's probability. And this is a random event that happened. It's not often at all that someone gets hit near a concession stand. It's far away in comparison to the stadium itself.
Is it true that the record showed that there was only one accident that ever happened?
Yes, there was only one accident in the 8 years, or the 8 seasons of O'Yarn Hill's baseball team.
But should the court really even care about that? Because if the Supreme Court adopts it, this is the rule across the country. There's baseball played from Little League to Major League stadiums every day. And part of the game is that balls are going to go out into the stand. So certainly someone's getting hit every day somewhere. So why should we care that in this particular instance, sure, there was one accident in 8 years?
Can you rephrase?
Sure. As the Supreme Court here, we're making the rule for the entire country. I get that in this particular instance, O'Yarn Stadium only had one incident of a foul ball causing injury to someone. But if we were to side with you, which you sound like you want us to adopt the baseball rule, it will apply everywhere. And with that many baseball games across the country, surely someone would be getting hit by a foul ball on a daily basis. So I'm saying, why should we care that here was only once in 8 years?
Because it's...
Does that go to your foreseeability argument?
Yes, it would. It would argue that the foreseeability... I'm sorry, this is echoing. I'm going to back up a little. It would argue that the risk is low, if anything, if it happened once in 8 years, especially because of where it happened.
But is it true that current jurisdiction does not have the baseball rule? Isn't that true?
That's correct, yes. It was
But you want us
to re-adopt it.
to adopt it and apply to everybody else?
Yes.
Isn't that the role of the legislature, though?
No, Your Honors. I believe that the legislation safety standards for baseball stadiums would be unnecessary and counterproductive. Stadiums already uphold the industry safety standards, and the courts have a robust framework to address liability on a case-by-case basis.
And, well, in that case, counsel, why wouldn't we just I'll give it to you. A majority of states have adopted the baseball rule, but a bunch of states still haven't. And you're saying that everyone's already across the country meeting the minimum, the standard in practice. cases where people are hit by foul balls go to a jury, and the jury can decide whether the stadium owners did enough.
Your Honors, respectfully, I feel that I won't say it would floodgate the lawsuits, but I would say that the consistency and predictability and liability for spectators and stadiums becomes at stake with an action like that.
Doesn't it all come down to the duty, actually, of the stadium owner?
The duty of care?
Yeah. Isn't it very similar to the baseball rule anyway?
My understanding, counsel, is we're preventing people from getting to a jury. By adopting the baseball rule, you're defining the duty, and you're not letting these people, get to a jury. And maybe with that, there'll be innovations in safety in the game. If someone's scared of a verdict, they may put more netting, or they may make other areas where people could get hit safer. Why would we not want that?
It takes the inherent fun out of the game. And I'm not saying that fun necessarily outweighs safety when I say that. Excuse me 1 minute.
Florida doesn't have the baseball rule. Is that correct, counsel?
That is correct, Your Honor.
So, if they're able to function with multiple professional teams, colleges, why shouldn't we just think that everyone can just have a negligence standard applied?
It's less about the fear of a lawsuit and maintaining a fair and practical standard involved.
Are there any cases that you can point the court to that you found persuasive that when we write our decision?
Are you asking for my most important case?
Yes.
Yes, Your Honor. Give me 1 minute, please. I would like to talk about Friedman versus Houston Sports Association, a case which ruled that a stadium doesn't have a duty to warn its patrons at all. And yet, Yarn Hill still decided to give several forms of warning before going above the precedent set in this case.
How long has the baseball rule been around for? When was it first adopted? I believe in preparing, I believe it was in the 1800s, right? So hasn't the game gotten much, more dangerous since 1893 when the first iteration of the baseball rule came about?
Yes, players are bigger and stronger now.
So
Your
should
Honor.
we be moving away from it? Why should we, adopt this antiquated rule? And if we do adopt it, should we make some caveat about why should we not differentiate concession areas from the general grandstands?
Will you repeat that?
Sure. Why should we adopt it? And if we do adopt it, why would we not make some caveat between the general grandstand area and other areas, like Mrs. Wagner was hit here, near a concession area?
Well, it's impractical and unnecessary. It's not a stadium's obligation to remove every single risk, and it would impact, as I said before, the experience and diminish the game itself. It obstructs views and it interferes with the unique enjoyment of the game.
And is your position that your corporation did everything possible to prevent injuries in the stadium?
Yes, it is my position.
Wouldn't that be under the rule that we currently have of negligence? Wouldn't that suffice to protect your client or the corporation from any liability instead of having us adopt the rule that doesn't apply to this current jurisdiction? If you did everything that you're supposed to do to protect the patrons attending your games, as I believe you're arguing,
Yes.
why do we have to adopt a different rule if you were already meeting the normal negligence standard?
You may answer and briefly conclude.
Because it won't create a doomsday scene. It gives a sake of consistency and predictability. It makes it so stadium owners have an easier time to figure out when they're liable and when they're not liable. It gives them a limited duty, and it makes it easier for them to manage, especially because it's harder to see everything all at once. I would just like to conclude with not all risks can be foreseeable, and there are limitations, and in this case, it's just too specific. Your Honors, the opposition's arguments are all a stretch.
Thank you, counsel. We'll now hear from respondent.
Good evening, Your Honors. May it please the court, my name is Emily Guba, and I stand before you today alongside my co-counsel, Olivia Excel. We represent the Wagner family, and more specifically, their son, Kevin, whose rights have been infringed upon by the school's haircut policy. The haircut policy is a regulation set by the baseball team that requires male students to cut their hair to a length that was set by the baseball coach, which is above shoulder length, to promote a clean-cut image for the team. In this case, Kevin's hairstyle is a personal expression of his individuality. Therefore, the haircut policy violates Kevin's 14th Amendment rights to due process.
So let me ask you about the due process. I want to ask you the same question I asked petitioners. What specific right under the 14th Amendment do you claim was violated by this policy?
It is his right to liberty. And with this, the school's policy unjustly infringes upon these constitutional rights.
And by liberty, you mean his liberty to wear whatever length of hair he wants?
Yes, Your Honor.
Okay, so assuming that we agree with you that that is a protected right, then the remedy is he would get a hearing, right, under the due process? You get due process, right?
Yes.
And then you would have to justify why he should be allowed to wear a hair the length that he wants versus the school's interest in having him having shorter hair, right?
Yes.
So what is the legitimate reason behind the school corporation for having that short hair when you're playing baseball, if there is one?
It was a policy. It was set by the coach to just promote a clean-cut image for the baseball team, which is not a good enough reason to have Kevin cut his hair
Why is that?
Because it is protected under the 14th Amendment, and Kevin is able to have his hair and wear his hair however he would like.
But schools have the right to regulate even certain rights these students have, right? In order to have a safe school, or if fosters the education environment. Isn't that true?
Yes.
So why in this case, in this particular case, would the school not have a legitimate right or a legitimate reason to have a policy such as the one that you're arguing against?
Well, the policy's restrictions regarding hairstyles are arbitrary and lack any rational justification. There's no evidence that Kevin's hair length negatively impacts athletic performance, safety, or the school's operations in any way.
So the 11th Circuit in the Davenport case had upheld a rule saying that interscholastic athletes could be required to be clean-shaven. And then in Humphreys, a Louisiana court made the same sort of determination. Should we not find those circuit decisions persuasive? And if not, why not?
They don't really apply to this case, because in this case specifically, the school has failed to provide sufficient evidence that long hair on male athletes poses any legitimate health, safety, or disciplinary concerns. Without such justification, the policy cannot stand as reasonable or necessary.
Haven't a number of haircut policies been upheld, though, where there wasn't a justification of safety, it was that clean-cut image? Isn't that enough?
It is not enough, because his right to personal expression, and there is no evidence that it proves any safety or health concerns, so the coach and the school cannot regulate his hair length.
Counselor, I don't know that it's completely arbitrary. I think that sounds like a bit like hyperbole. I mean, the city and the coach, they have a reason for doing it. I want to back up and talk about what the proper standard is. I mean, there a fundamental right? Because if the right to wear your hair a certain length is a fundamental right, then the government needs to provide a compelling reason to restrict it, okay? But if it's not a fundamental right, all they need to do is pass what we call the rational basis standard, which is incredibly low. And you can try to argue to us that there's no basis whatsoever for this rule. I'm telling you now, I wouldn't buy that. There's some sort of rational basis. So I think it's key that you establish that this is a fundamental right to reach a higher level of scrutiny. And I have to say, I'm somewhat skeptical of saying that this young man had a fundamental right to wear his hair a certain length. You know, I couldn't help but chuckle to myself when I was reading the 14 Circuit's opinion with this highfalutin language. For instance, the right to wear your hair is intimately personal and a matter of grooming. I mean, how is wearing your hair intimately personal? I mean, to me, intimately personal is what you do in the bathroom or a conversation you might have with your spouse in bed. I mean, that's intimately personal. To me, the way you wear your hair is the reverse of intimately personal. You are out showing it to the world. Most people wear their hair a certain way, especially teenagers, to say, notice me. So I have deep reservations about saying that a teenager has a fundamental right to wear their hair however they want. I'm also concerned as to the precedent and what that could lead to. So how do you respond to that? Why is this a fundamental right such that we are going to scrutinize it so closely under the United States Constitution? Again, a teenager's right to wear his hair down past his shoulders.
Yes, Your Honor. In response to that, I would like to point you to a case. I would like to point you to Breen versus Call, and this case is directly applicable as it struck down a high school grooming regulation requiring boys to keep their hair short.
Fair enough, Counselor, but bear in mind that we are the high court in the land, so we don't have to follow the Seventh Circuit, and I believe that the Sixth Circuit held the reverse. So I come back, why should we follow the Seventh Circuit and find a fundamental right to wearing your hair a certain length? That's a fundamental right. Versus the Sixth Circuit that said, get out of here, this is not a fundamental right.
Yes, it is a fundamental right because it isn't just while he's playing baseball. It's when he goes home. It's how he sees himself. Therefore, both him and his parents have a right to this personal expression in how he decides to wear his hair.
Okay, so that's an important point because freedom of expression is a fundamental right, right? It's guaranteed under the First Amendment.
That is correct.
We're not dealing with First Amendment here, right? We're dealing with 14th Amendment, and you have a due process claim, and you have a substantive due process claim, right? So, is that correct?
Yes.
Right. So if you have a due process claim, I think we went through the policy, and you explain why the policy has no rational basis. But let's move on to your substantive due process claim now. Why is Kevin's due process claim violated? Substantive due process claim violated.
Can you just restate that?
Yeah. So you have your due process claim. Due process claim involving the policy has to do with whether the policy had a rational basis, right? Whether he was provided an opportunity to challenge that. We're past that. I want to know about his substantive right, which you described as his right of expression. Or under the 14th Amendment, his right to liberty, right? Okay. So why was his substantive due process, why his right to liberty violated, given that we saw some of the cases that actually allow the government to regulate even certain fundamental rights can be regulated. Like, for instance, you're familiar with the armband case, Tinker v. Des Moines, right?
Yes.
So that is a case where there was a fundamental right, freedom of expression. So why is this case different, and why should we find that Kevin's substantive due process right was violated here?
It was violated because of the fact that he was not allowed to play baseball unless he cut his hair to the length that the coach wanted it to be.
So he had the right, there's a policy that prohibits him from having his hair at a certain length. And then in order for that policy for us to uphold that policy as constitutional, the school has to show a rational basis
is not enough to have Kevin cut his hair. He could just pull his hair back and put it under his hat or under his helmet and have that same clean cut image that the coach would like.
Isn't the opposite true though, counsel? So this haircut policy seemed to allow a lot of expression. As long as the hair was above the shoulder, he could wear it however he wanted to. Isn't that correct? So that's 1,000 different hairstyles. So why do we have to make it so he can wear it longer?
Because that is how he would like his hair to look. And the coach does not have a right to make Kevin cut his hair to this length.
Should we make anything of the fact that he cut his hair his junior year to play baseball? Is there a waiver argument that your opposing counsel could make there? And if so, is it justifiable?
That is talking about his junior year. He is now deciding he does not want to cut his hair. This is different than when he did cut his hair.
Do you find it arbitrary that the policy allows a coach to make such an important decision about someone's right to liberty?
Yeah, the coach should not be able to make students cut their hair just to play baseball.
What about your equal protection claim? Tell us about that, because I think that's an
Yes.
important part of your claim.
Yeah, this policy also discriminates against students with longer hair, especially male students, and it fails to apply equally across different groups or activities. The case states that the mandatory haircut policy is not applied to any girl trying out for any sport. So this gender-based discrimination is unlawful and unjust.
Counselor, just remind me, what standard are we looking at? Would you agree with the proposition that a law can discriminate between men and women?
Can you just restate that?
Yeah, would you agree with the proposition that a law can constitutionally discriminate between men and women?
Yeah.
It can, correct. I
correct.
agree with you.
Yes.
So what's the standard? When does that discrimination become unconstitutional? And it's a follow-up question, of course, why is this unconstitutional?
This is unconstitutional because of the fact that only the baseball team had to cut their hair.
Right, again, but I come back to the point, I understand. I'll accept the premise that we are discriminating that this policy discriminates between men and women. But it's clear that you can constitutionally do that. I believe the standard is if the government advances an important interest. Why do we not have an important interest here? Okay, so I'm accepting your premise that the law discriminates between boys and girls, but that's not always unconstitutional. The courts have found there's certain instances, just based on the basic differences between men and women, that it is okay in certain circumstances to discriminate between the two genders. So I'm asking you, why in this circumstance, under these facts, is the discrimination between men and women unconstitutional? What is the important interest or lack thereof in this case?
It is unconstitutional because of the fact that this baseball coach, none of the other coaches require any policy that is stated that requires students to change their image and change the way they would like to express themselves.
To go back to the due process argument, shouldn't we be viewing this like in the context of students choosing to participate in extracurricular? Hasn't the court held that they're different than students attending school corporately otherwise? So why should it just almost any justification be enough here?
Kevin, he has a right to participate in this extracurricular activity as part of this school. So I would like to move on to my conclusion. So the haircut policy, Your Honor, is unjustifiable, discriminatory, and arbitrary. It infringes upon Kevin's rights to expression, equality, and participation in school life while violating due process and undermining parental autonomy. For these reasons, we respectfully request that the court find this policy unconstitutional and order its cessation, allowing Kevin to fully participate in education and extracurricular activities without unjust interference. Thank you, Your Honor.
Thank you,
Mr. Justices, and it may please the court, my name is Olivia Excel, and I'm honored to represent the respondent today with my co-counsel, Emily Guba. Fundamentally, this case raises concerns based on fairness, safety, and the proper application of legal principles, however, in the context of a public high school sporting event. The central issue I will be outlining for the court today is whether this baseball rule, a doctrine that's historically applied in professional sports, should govern this case. We respectfully submit that it should not. Instead, this court should apply a general principle of negligence as well as a reasonable duty of care in order to access the duty owed by the Yarn Hill School Corporation. Both of these solutions also hold the stadium operators accountable without imposing on undue burdens.
Counsel, the baseball rule is the majority rule, right? So why don't we
Yes.
just, make the rest of the states follow along?
Your Honor, the other states should not follow along because this just generalizes the assumption that all of the spectators assume risk evenly, and that is just not the case. But firstly, I would like to draw the attention to the context of the baseball rule. The baseball rule, as created, fails to align with a high school setting. This is because, as we have seen previously in the cases Atkins and Turner, the rulings of the baseball precedent reflect assumption that spectators at professional games both understand and accept the inherent risks of baseball. However, Your Honor, such assumptions cannot extend to a public high school setting. At Wright Stadium, attendees include children and other individuals who lack awareness and expectations that professional spectators do. Furthermore, the doctrine's duty of care, which limits protection in most of the dangerous areas, such as behind home plate and all of that, is not substantial. This limited duty principle aligns with the expectations that spectators, as I said, in the professional baseball games, align with, say, ones of high school parents.
But having a baseball rule seems to be something of judicial economy in the sense that it's a well-defined rule. As long as there's seating, a behind home plate that's sufficient to meet demand, the baseball stadium owners know what they have to do in order to meet the needs of their spectators, and they're not going to be sued for it. We're just defining the duty.
Yes.
Isn't that just simpler? Why should we not want less cases going to court?
Well, the policy is just too narrowly tailored because, oh, I'm sorry, actually, could you reframe that last part of your question, Your Honor?
Sure. So the two universes would be a simple negligence standard applying. There's a duty, and we find if there's a breach of duty, which caused an injury, or in this special circumstance, we're adopting the baseball rule, which is just making the stadium owner's duty very clear. We don't have to worry about how much netting is enough. All we have to know is that if there's enough seating behind home plate, then that's what they needed to do. They met their duty. Why is that rule, which is simple in its articulation and easy to practice, why should we not be adopting it?
So we should not adopt the baseball rule as a whole because just because the baseball rule does say, as you stated, that as long as there is sufficient netting behind home plate, then it's basically saying that the stadium operators are not liable for injuries. So that is a problem in this case because the Wright Stadium operators possess a reasonable duty of care to their patrons. Because the key question here is, did the defendant owe a duty of care to the plaintiff? Yarn Hill School Corporation did owe Karen Wagner a duty in the safe environment.
So even if we accept that as true, isn't it true that there's warnings around the stadium? It was printed on the back of the ticket. Mrs. Wagner has been to a bunch of baseball games before and knows the inherent risks. Why should we be taking the assumption of risk into account?
We should be taking the assumption of risk into account because I actually, in the preparation, I saw that in Ball, it stated that landowners are required by law to exercise reasonable care in order to keep their property safe to anybody who is invited.
But
Therefore,
I think what my colleague is asking, wasn't that reasonable if you have a ticket that warns you about
the baseball rule. So my proposal is if we decline this baseball rule, we could implement a negligence framework instead, which would in turn lead to more safety in all of baseball games.
So
Does that answer your
what would
question?
So I understand your distinction, which I think it's an important one, about the duty owed by a high school versus the duty owed by a stadium owner. However, this game was played at a stadium, right?
Yes, it was.
Okay. And so what is that we should adopt if we decided not to adopt the baseball rule? Should high schools have netting all around the field, or spectators have to be protected by netting throughout the entire field? How are we supposed to address that?
No, Your Honor.
If we even have the responsibility and the right to do that.
So that is a great question, Your Honor. So actually, my client, Karen Wagner, was, you're welcome, she was on her way back from the bathroom, and therefore, she was not able to see the batter in this instance. So my solution to that would be not to put netting around the whole stadium, however, in the areas, near the concession stands or the walkway where she was injured, because that is a place of like high foot tracking.
But isn't it true, the facts, at least the fact can recall, is that she wasn't really paying attention to the game. So had she been paying attention to the game, even in the area where she was hit, would she have been injured the same way?
That is not, that's like a probability concern. That is not.
Right, but that goes into what counsel argue about the
Yes.
assumption of risk, right?
Yes. So the assumed risk, though, it kind of falls into, it's similar to the duty of care that the stadium owners, like I said, express, because they have, so there's 4 things that we look for here. It's the fact that, was there a duty? So yes, there was a duty here. The breach or causation and damages. In my case, in this instance, is that for my client, all of those are apparent here. So risk isn't abstract, though, but it's foreseeable.
And risk here is particularly foreseeable, right? Because
Yes.
Mrs. Wagner is going to a game where balls are intentionally batted. They're hitting them. They're going to fly somewhere. This seems very akin to me of downhill skiing, right? The mountain is a dangerous place. Just because someone's behind me, I can't end up suing them. I'm assuming the risk by skiing. And it seems to me that you're assuming the risk that you may get hit by a ball when you're going into the baseball stadium. So how are those two activities different, and why would the duty of care be much less because of the assumption of risk?
So the duty of care is much less under the baseball rule because it's a limited liability principle. So it automatically states that, say that there is sufficient seating behind home plate, that the stadium is just not liable at all, which is not just, it's not going to work for high school baseball games.
Isn't that maybe a good rule? I mean, Mrs. Wagner in this case, if I understand the district court, did not purchase a seat behind, or sorry, she purchased a general admission ticket, and she could have sat behind home plate, but chose not to. So doesn't that matter?
That does not matter, Your Honor, because she is an invitee of the stadium. So it is under the Yarn Hill School Corporation's responsibilities to protect her from foreseeable risks.
If we were to find that the corporation did everything it needed to do to protect its patrons, that it put netting where it's supposed to be, gave enough warnings where warnings should have been given, what is your best argument for us for not adopting the baseball rule?
Your Honor, my best argument for this would be to apply a comparative negligence approach instead.
What about the fact that the rule does not exist in the jurisdiction?
I'm sorry, Your Honor, do you mean the baseball rule?
Yeah. Should we be legislating?
No, I do not believe, or yes, I do, actually. That is a great question. I believe that if we mitigate the baseball rule and instead we apply these standards, it is up to the judiciary legislative to make those decisions. Therefore, not only would that increase the reasoning in responsibility for safety, but it would make the judges have a more comparative approach to deciding who is risk here.
Let's say the facts in this case, I take it that you think that the school district was negligent because she got hit.
Yes, Your Honor.
That sounds like you're arguing for strict liability, and frankly, that concerns me. I mean, more generally, what do you say to the concern that I understand that the New York Yankees can put netting all around the stadium if they want to. They have the resources, but I think everyone in this room has been to a high school baseball game, and all they have is a backstop, some bleachers, and a parking lot nearby. It sounds like you're almost arguing that if anybody gets hit at a game, that the school should be liable. And I'm a little troubled by that because I think, now the school district, let's say we say we're getting rid of the baseball rule, okay? Now the superintendent at a school says, hey, this ruling just came down. They ask their attorney, what should we do? And the attorney says, you know what, I think we should drop the baseball program because let's say somebody gets hit at our game and there's $200,000 worth of damages or, God forbid, $2 million worth of damages and we can't afford it, so we're dropping the baseball program. I think that's a legitimate concern here, especially given the way that you seem to be arguing this. So what do you say to that concern?
So that would fall under the negligence framework because under negligence, it does not assume that the school, for instance, would be liable. However, it's a fair and flexible standard to determine who is liable in this case. There's 4 elements, as I have stated earlier. However, the duty, breach,
Counsel,
causation.
let's say I'm not going to buy it. We're going to adopt some fraction of the baseball rule. What caveats should be in place, if any? Bring me to what sort of exemption should we make from the rule? Should it apply everywhere? My understanding is that in the cases where it's still being adopted, there are oftentimes geographical limitations.
Yes.
Explain what caveats we should make if we were going to adopt a baseball rule.
So if we were going to adopt a baseball rule, the baseball rule should apply to professional settings and not high school sporting events. In this case, Kevin Wagner, who is my respondent's son, was a minor. So this was a high school sporting event. You cannot compare the fans of a professional baseball game to ones of this game because that is just assuming that everybody has the same assumption of risk.
And you're saying for the amateurs, they should not have the baseball rule in place?
Yes, Your Honor. I believe that it should be up to the states to decide if the baseball rule is apparent here, but it should not be held in a high school setting. As we saw in Ball, landowners do owe that duty of reasonable care, and then O'Yarn Hill had that breach of duty when they failed to implement the reasonable safety standards here because they did not protect the spectators from all of foreseeable harm. The netting was only present behind home plate, leaving other high-risk areas like the pathway unprotected. And like in Friedman, that case was deemed negligent because of the lack of adequate safety measures here. So the absence of the netting is the standard there for the negligence. Therefore, I conclude that the baseball rule in this case is not only outdated, but it fails to account for a specific context at the school environment. Supplementally, though, the baseball rule is not expressly adopted. General principles of negligence must guide the duty owed. And an example of this is in Krebson's court. They declined to adopt the baseball rule, but instead they emphasized the importance of reasonable care under the circumstances. Similarly, though, in Rootney, the court held that liability should be evaluated through a negligence framework rather than assuming spectators accept all risks inherently. Therefore, that is why I feel that the baseball rule should just not be applied and it should be up to the general jurisdictions and legislatures to determine the cause of negligence. There's also a bunch of public safety concerns that I cannot get into today, but I believe that the best approach here would be a comparative negligence approach, like the one we saw in Scott versus Rizzo.
Thank you, counsel. We'll hear from petitioner on rebuttal.
Your Honors, I would would like to quickly address other cases that I meant to bring up prior. Benjamin v. Detroit, limits protected seating, and Rudnick v. Golden broadcast, patrons accept risk. These cases are very important as they accept inherent dangers. They let people know that this is what's available and what isn't available. I also would like to establish that the baseball rule is a very well-defined rule, and it sets precedent, and that the stadium did all that they could to take care of the assumption of risk. And it doesn't matter if she didn't read the ticket. She's been a lifelong fan who would know. Bats and balls, they're dangerous.
So, counsel, in some of the recent adoptions by states of baseball rules, New Jersey, New Mexico, a few of the state court cases in New Mexico first, they all distinguish seating from multi-purpose areas, or the area near the concession stand. Why should we, if we're going to adopt the baseball rule, why should we not do it with some sort of caveat limiting its application geographically, so that way a negligence standard applies, outside of the seat?
We believe that negligence standard would make things too confusing.
But okay, so the stadium owner is getting the benefit of all the advertising dollars, which take your eyes off the game. They make money off the concessions. They make all these monies where they're distracting you from the game. Why would a caveat of just applies in the seats, doesn't apply in those areas? Why does it not make sense? Give me your best argument.
You're asking why distractions should be fully available?
I'm saying if the stadium owner gets the benefit of all these distractions, they make money off concessions, they make money off advertising, why should they not have a potential liability for their role in taking your eyes off of the game?
Most of those cases are at big stadiums. This is a small stadium.
And so you're saying that we should make a distinction between amateurs and professional athletics, or what?
Yes, I am, because at an amateur level, there aren't advertisements like there are at a professional level. There aren't as many vendors. There isn't big screens with kiss cams. There's just not. I would also like to bring up, though, that there's only so much a stadium can do, too. As I've argued, or as we've argued, proximate cause and foreseeability all over the place. But I would like to give an example. A good comparison would be if a foul ball was hit into the upper deck and there was no protective netting, where there was no protective netting, and it hits an empty chair, bounces, and then strikes someone's phone, which hits them in the face. Is that then the stadium's fault, too?
Thank you, counsel. Take it on submission. Yeah. Just going to talk with them, and then we'll come back and do the whole rigmarole here.
Good job, everybody.
We'll be quick.
Yeah, you want to walk. You can go outside even.
All right, so just so we can get you guys out of here, generally about the competition, undergraduate students don't do this. So I had thought about doing something like this. I had looked into what sort of colleges do it. Harvard tries pulling it off. I think UT does. Maybe, George Washington. Or sorry, maybe it's Georgetown. But there's not that many schools that do it. And frankly, the people that would be judging, I don't know if there's a law society. I imagine there's a law society or a law club here. But you're getting judged by people who don't, excuse the expression, know shit about shit. This competition is better than, Yeah, oh, that's fine. You can't cancel me. This is, the framework is theoretically better than most law school competitions. Law school, the way it works, you try to argue on to be on the moot court board, and it's other students that are on there, but they're typically 2 Ls and maybe some 3 Ls. But not a lot of people travel around or actually do this, because you'll find that the competition in a small pond like the school is much different than it is once you get out into like these national competitions. Each of the preliminary rounds, every team that signed up and wanted to go had a chance to argue both sides of the problem. And they did so in front of 2 practicing lawyers, with the exception of 2 people. The head of the University of Connecticut's moot court board, who's traveled around the country in these competitions, and another person on the executive committee there who did the exact same thing. Everyone was lawyers. Having to argue both sides of this problem, well, let's step back. This is different than most college courses. It's not a regurgitation of information. That doesn't matter. You have to think critically, you have to use facts, you have to use arguments to your advantage. And unlike just furthering your argument like this was debate club, you have to understand the intricacies of your argument and where it's weak, because you're gonna have to be able to argue the other side. You have to have a fundamental understanding of what's happening, right? And that doesn't even address the component of public speaking. There's a lot of things that went into this. And it's funny because in doing this, I either judged a lot of rounds or getting my friends to do it. My friends took an interest in this. And a lot of my friends have no affiliation with Hartwick. So it's introducing Hartwick students to people that have nothing to do with this. Don't know Yarn Hill, couldn't tell you, anything about this place. And, vast majority of their feedback was incredibly positive. I have people texting me about the live stream right now, about audio and stuff like that. Some people that aren't even lawyers, watching along. And they did compare our production value to a Mac game, so we got to up that for next time. But it's funny, in this room, Emily, I'll pick on Emily for this. I had Emily's first round, and Emily was struggling, right? She couldn't speak. If she was asked a question, she had a difficulty answering these questions, and it wasn't because she had lack of preparedness. She's just trying to find, what the answer was in this outline of papers she made, and it wasn't there most of the time, and she was getting frustrated. Her second round, the scores were so much better. And look at her now, commanded the room, did it. It's an amazing improvement. Madeline did a great job. Madeline tried to argue that we have a fundamental right to be naked all the time. That's a tough position to take, and she tried doing it. It's because she from TV doesn't understand that you have to learn where your argument ends, what you have to concede. You're not just arguing for the sake of arguing. Emily argued the wrong side of the problem for a second, had to win it on a rebuttal. These are mistakes that, you're learning something. They're learning how to interact with professionals. Again, these are attorneys that they're dealing with. At first I was getting these things, can we bump this argument by 15 minutes? And I'm like, oh yeah, sure. The people that bill $500 an hour, I'm sure they give a shit about your, whatever. People start to take things more seriously. You're learning in a professional environment. They would get feedback on their presentation skills. They would get substantive arguments, how to make these arguments. You don't have any basis in law, but what you did is better than what I saw in court this morning. This is something. It really is. not even like, again, I don't think he's here anymore, but there was an individual who was with the other round who might have put on the best oral performance we've had this, argument session. It's like, that was in front of a board member for Hartwick, who's an accomplished employment lawyer, and a guy who is certified to defend capital cases. And he's argued. The people that made it all the way through, you've argued in front of people that have litigated at the Supreme Court, on cases. This is pretty cool. And some of the things are much smaller. There was one student who I'm sure isn't here, but his first round, he tried to act like he didn't care, and that was his real thing. It's just like he was just too cool for school. And one of my friends made a comment to him, be like, "You obviously prepared. You have the answer. You're just fidgeting and you're trying to act like it doesn't matter." And then that must have resonated to the point where his second time he went was so much better. In fact, they commented that he was probably the second best person that argued that day. So it's like, you may not see it because everything feels incremental when you're doing it, but you've made a lot of progress in what you're doing. With that said, I'm proud of everybody, but we'll finish this up. So before we do who won and best oral, if you guys want to say anything? Well, I made you drive here.
Brief. Again, as I said earlier, what you guys did, it's really impressive. This was a very complex problem with constitutional questions. And I bet you if I bring this to some of the attorneys that I know, they won't know the answers. They will not know the law as well as you presented to us today. So you should be proud of yourself. What you did, it was really impressive. You should be proud. It doesn't matter. I think you're all winners. I heard there was 60 competitors. And the fact that we got 60 students from Hartwick to compete in a moot court competition, for me, speaks volumes. And congratulations to you, to the political science department. This is amazing. So, I don't even know how to express how proud I am of you guys. But in terms of my comments, yes, you are high school students. You don't have the legal background necessary yet to argue a complex constitutional case, yet you did it, okay? You prepared. You're not used to having guys like us wearing black robes asking questions. For most of the times, you were very poised. You didn't seem that, upset about it. You got to see some arguments. You can actually watch some arguments live, and some of the attorneys get upset. They get nervous. So you did great. The point you made was excellent. Sometimes you got to concede, and that's a skill that you're going to learn as an attorney. I was throwing some softballs sometimes, waiting for you to concede some arguments, but you stuck to it. And judges don't like that. So sometimes the best thing to do is, yes, Your Honor, you're right about that, but then you make your argument. But in this case, it's different. Or that's the distinction. So you got to concede. Sometimes the judges are asking you a question. So most of the times we already know how we're going to decide the case. Not us, but judges. Okay. It's very difficult to convince an appellate judge to change his or her mind. So when you are there, you got to be top. You really got to focus on the most convincing, most strong portion of your argument and go for it. And if you have to concede the bad ones, concede it right away. And focus on what is strong about it. Because that's what you may carry today. You may convince one or two justices that you're right. The other thing is, and that obviously comes with practice, but I guarantee all of you, if I sit down and start talking to you about something that you care about, I don't know what it is, but baseball or TikTok, whatever it is, you're going to look me in the eye and you're going to have a conversation with me and you're going to convince me of why that thing that you care about is important, right? And that's appellate argument. That's what it's all about. Like you representing your client, you impersonating your client at the podium, and you have to look at the justices and convince them that you are right. So that comes with time. But I I have notes, I look at notes, I have the case citations, but I'm so prepared, when I get up there, I'm so prepared that I want to have a conversation with the justices. They know the law, I know the law, but let's have a conversation about what is important about my case. And that makes it much easier for you. If you're having a conversation rather than trying to memorize what you wrote down, it makes it much easier. So, but again, it comes with practice. There are attorneys out there who don't even do that. So you guys did a phenomenal job. I'm very happy for the invitation. Thank you so much for inviting me to be here, and I'm so proud of all of you.
Yeah, thanks. Just want to echo that sentiment. Thanks for having me up here. It beats working, getting to do this moot court. So I had a lot of fun. I don't know, how many people in this room will end up going to law school and being attorneys, but I hope you got something out of this no matter what you decide to do in the future. And two takeaways come to mind. The first is I think this is great for you guys just to get an understanding of how the law works. I think this is very much pertinent in the current climate. Right now, the United States Supreme Court is getting a lot of attention. I was just thinking about if this were real and we upheld the school's haircut policy. You might see it written up in the newspaper. The conservative Supreme Court reinforces gender norms by saying that boys have to get their hair cut. And what I hope you got from this is that these questions are actually more complicated than a headline, and you're not arguing about policy. You have to break it down into an issue. Okay, is it a fundamental right? If it is a fundamental right, there has to be a compelling reason to circumscribe that right. If it's not a fundamental right, it just has to be rational, or it has to make some sort of sense, very low standard. But I hope what you got from this is that the law is complex and it's not policy. You have to identify the issue, you have to apply a standard, you have to consider precedent, and put all those things together. And so I hope that's something you took away from it. And now when you read the newspaper, or even the New York Times or the Wall Street Journal about some Supreme Court opinion, that you understand that it's a little bit more complicated and that they wrestle with these issues in a way that's more nuanced than is sometimes written about or perceived by the general public. The other thing that I hope you take away from this is just how to prepare to speak in public in general. I don't, again, maybe nobody ends up going to law school in this room. That's really not the point. If you're going to be a successful professional, you're going to have to speak at some point. And you're going to have to speak in front of people. And if you want to be very successful, you're going to have to do it all the time. And so what I hope that you got from this is probably, I suspect what you learned, because I know it's what I learned when I first started doing moot court, is you have to prepare. You have to practice so that it sounds casual. And you're ready, you anticipate the questions that are going to come up if it's a question scenario. And so what I hope that you take away from this, everyone in this room, right, is going to be interviewing for a job in 2 to 3 to 4 years. That is a form of public speaking. I mean, it's one-on-one, but you're going to have somebody grilling you. You need to be prepared how to answer that and think through what questions you might get. So this is great experience for all walks of life. It could be great experience even for speaking at a wedding or some sort of social event. And so I hope that's another takeaway you got from this. So again, thanks for having me. Tom, awesome job putting this together, man. I mean, it's just great stuff. I mean, you made a real impact on your school beyond writing a check at the end of the year, man. So well done, everybody. Great job.
All right, so last few things. One, the other thing which I think people start to appreciate is for example, Mike had judged multiple of those rounds. And in order to judge these rounds, you have to, do what you did in a way. You have to read the problem or at least have an idea. I gave the judges a cheat sheet, but you're still taking away hours. The amount of hours on the outside of Hartwick College that would have been spent on this, outside of, Professor Chick and Professor Elder's work, legitimately hundreds of hours that would otherwise be billable at hundreds of dollars an hour. So this is some sort of a production here. And with that said, the reason why back to the release of the problem, the problem was named after a high school teacher I had who would consistently do stuff that they didn't need to do. I went to school in Warrensburg, about an hour north of Albany, near Lake George, and there was a teacher, E.O. Bruce, who has since passed of a brain aneurysm, but she would do everything. JSA, I went to Boston, would get exposed to, people in other settings arguing. I mean, the only time I got that was sports, like playing AAU basketball or something like that. It was a different setting. She would take kids out of the country for their first time. Kids that had never seen New York City. There'd be trips to museums, whatever. She was consistently doing something that brought value outside of an educational setting. So that's why this is named after her, E.O. Bruce. Now, before we announce who won here tonight, the best oralist. The best oralist was based on the preliminary round scores, and it's named after someone that Mike and I know very well. It's changed my life in law school, even though I took his class only my third L year. And that's based on Richard Pomp, who's still practicing. He teaches at NYU, teaches at UConn. He's taught at Harvard, Columbia, Tokyo. He's set up state tax systems, international tax systems. He's a leading expert. And he flies around the country. He's been in every big tax case. He's the man. And there's three things, well, there's a lot of things Professor Pomp does well, but I put in our thing that there's three things he does well. I said, Professor Pomp is one of the best and sharpest legal minds in industry. Anyone who has the consideration for best oralist, and there was a number of people, the scores were close, will be mimicking at least three of his best attributes. The ability to communicate clearly and make the difficult digestible, to never shy away from tough questions, and to find ways to add value for clients. So the person who won Best Oralist, promptly named and gets this nice little gavel with his name on it, is a participant whose partner dropped out. And she still decided it was easier, could have went and not did it, not taken the time, but she did it anyway. So Rosalind Doomerville. Finally, again, it was a good job. I hope everyone actually found that enjoyable, even if you didn't know anything what was going on. And in this case, who finishes second, you still walk away with $500 each. That's good beer money. But for the big money in the championship, Olivia and Emily, you guys won. You responded. Again, the way this worked was sometimes the best oralists and rounds did not move on. It was a team effort. And again, everyone very much improved, but what you ended was a very good final product. There are other people that could have been up here doing the same thing, but you know what, they're not. And you guys did, and you guys won. So congratulations, thank you very much. And that's it. Besides, we're gonna need a picture with the best oralist and the winners. We got the